packed house. Recording in progress. It's a packed house. Obviously, the camera can only see this direction, so you don't know. Sorry if it's loud, a lot of cheering. Welcome to the virtual people. Welcome to the real people. I know you're virtual people too. I am Andrew Goodwyn, one half of Hendley and Goodwyn. Guess which half? And
I'm Holland, Hendley, the other half of Hendley and Goodwyn.
That's right. Today we are talking about, as you'll see on the next slide, how to avoid key legal mistakes in startup companies, small businesses as you get going. So just a quick little bit about us. Go back to the last one actually. Holland and myself went to Texas A&M School of Law, and that's where we met, and we decided to strike out on our own, hang our own shingle as they say. And we do entertainment, esports, business, and intellectual property law. So do quite a lot of transactional stuff, and we do a little bit of dabbling in litigation, which people say you can't dabble in litigation. So we can talk about that more. All right, so today, key legal mistakes to avoid. First things first, you want to pick the appropriate business entity. A lot of people start out as sole proprietor. It's the obvious way to start. The most common thing we see is that people pick something just because they Googled it, and the first blog they said was like, hey, go incorporate in Delaware. And just some fun facts about that. The reason Delaware is such a popular choice is because back in the day, Delaware had a court that would basically fast track all of the corporate stuff. And so they have this big body of corporate law, and that dictated a lot of the way that the laws went, and that's why people chose to incorporate there. However, it's 2021, our laws are becoming more and more uniform as we go, and so most states have really updated and modeled themselves after the Delaware structures, and so now, in my opinion, you'll hear different opinions, but generally it's best to incorporate where your nerve center is, right, where you're doing the most business. And there's definitely different advantages in different places, right? Tennessee is great, no state income tax. Who likes taxes? Raise your hand if it's nobody, we don't even have to wait. Yeah, so Delaware, popular choice, maybe not so necessary. So there's a lot of different types of business entities out there, as you'll see on the next slide. Sole proprietor, right? That's just, you just start going, right? There's nothing there. General partnerships, please never do this. We won't even talk about it, okay? Because you should never do it. If anyone tells you to do it, turn around and say it was nice meeting you and never talk to them again. What's right for almost every small business and company is a limited liability company, an LLC. Now, a lot of startups also favor the corporation, and that's because when you're a startup company, like startup seeking investment, as opposed to just kind of small business, there's a little differentiation. But when you're in a startup and you're seeking investment and stuff, a lot of the bigger investors like to see corporations. Again, in my opinion, the reason for this is just old school thinking. You know, we've done deals on the other side of a Fortune 100 company, and our client was an LLC, and they didn't care, right? Fortune 100 company. So it's again just kind of an old school of thought. The limited liability company is great for small businesses, in my opinion. There are some nuanced reasons why you may want to go with a corporation, but it really is nuanced, and that's something you would want to sit down with an attorney and talk about more. Limited liability partnership, that's what we are. Partnership, so kind of real similar to limited liability company, but and then professional limited liability company. We see a lot of law firms like this that kind of eat what you kill law firms set up like that. But we're a 50-50 split because we love each other in a friendly way. Olin, you have any comments on this?
Yeah, I think the big thing when you're considering entity types is to look at kind of your overall scope of your business and what you want to accomplish. The thing most entrepreneurs are familiar with from this point of view is your business plan. So your business plan is what everybody here is going through business school and talking to, other business professionals like, okay, you got to have it. Well, a business plan is, a bunch of different items that you want to consider when you're picking your business. And a big one is your legal structure. It's how are you going to structure your profits? How are you going to structure your losses? Who's going to make decisions in the company? How are we going to vote and consider those decisions? And what's going to happen? The classic lawyer thing we have to ask is if somebody passes away or becomes incapacitated. These are uncomfortable questions to sometimes confront, but you have to do it. You have to just address things because, as we all know, life happens. Stuff goes down that you never anticipate, and it's important to at least have some sort of proactive plan, so when those actions or occasions or events happen, you have something to deal with it in place, something that you're not totally just caught off guard or off your feet about. You can look to a document, you can look to like your professional advisors, whether it's a lawyer, if it's a tax issue, what have you, and you can consider, okay, here's what we do to address this. And then, you will likely go to your other business partners and make decisions based on that.
Yeah.
But anyways, saying all that, that's why a business and your entity and your internal structure matters so much. And what is going to fit for you really depends upon the circumstances. Like Andrew said, a small limited liability company is going to be appropriate for a lot of small business owners. I'm talking companies that are just a couple of partners maybe, or just one partner, really. But whenever you get into a larger structure, something else may be more appropriate. Maybe you look at your business plan and it's like, okay, I know in 5 years, I want to be at this threshold. Okay, well, that considered, maybe there's an alternative structure that might be best for you. Or maybe it's something to set up in a simple way now and then confront other problems down the road. A big thing you want to consider is that you only have so much startup money, and that has to be allocated very strategically. We talk a lot about budgets, for our own law firm and, just in our personal lives. It's like you have to be smart with your money when you're going to start a company, because if you're spending more than you're making, you're not going to be in business for very long. So the big thing is to kind of reduce transaction costs where you can. Now, if you form a corporation, which is like the tried and true traditional advice you've been hearing for probably 100 years, because corporations have been around for so long. The trouble with that is you've got to run your company by committee, basically. You've got a board of directors that every decision is going through. You've got to hold meetings. You've got to vote a certain way. There's a lot of just formalities that overcomplicate the thing. We're talking like just big bureaucracy that is just cumbersome and weighs you down. So if you're a smaller business and you see an opportunity in the market that you want to take advantage of with your product or service, then an LLC is going to allow you to be better prepared for that. If something happens one day where you're like, oh, we just got, a key source of funding to where we can launch and go to market, well then, okay, a limited liability company, you can make that decision very quickly. Whereas, a corporation might hinder you in a way that's not necessary. And that's not even considering the fact that corporations get taxed twice, which is what we all want to avoid. So yeah, there's a lot of attributes to each of these entities that you have to consider. And so it's best just to sit down with your attorney, go through, and not even just your attorney, maybe your accountant or other people on your team, and go through everything you're anticipating in like a 1 year, 3 year, 5 year scope, and then make decisions based on that information.
Yeah, and also if you guys have any questions along the way, just throw your hand up and we'll address them. If anyone hangs in that chat, I'm sure Parker can see it and he'll let us know. But yeah, the beauty of the LLC is that you're doing business sort of on a contract basis, right? If you want to run your LLC like a corporation, you can do that, right? You put it in your operating agreement that you have a board, that you got to keep track of the minutes of your corporate meetings, you got to have this many meetings each year. You can do that, right? You can run it. You can even elect to be taxed like a corporation if you're running an LLC. So there's definitely a lot of ways you can swing it, and it's kind of just doing business how you want because you get to contract that way. And LLCs are relatively new, right? They're not new. They're relatively new in the business world. So when you're setting up your LLC, you want to get your operating agreement done. So if let's say you have 2 partners, right? Your operating agreement, you're considering all those things on mentioned, and then you have a cap table at the bottom that's talking about, okay, if you have 50% interest and you put in this much investment, or you're putting in sweat equity, those are things you want to prepare for, because when you don't, you fall back just to the statute, right? And if something goes awry, which it tends to happen, right? A partnership breaks up or something happens, you want to be able just to look to your operating agreement and say, this is the procedure, this is what we follow, and then you're done. And it doesn't become this big, oh, well, he said that if I put in 50K, I would have 50%. And all of a sudden you have he said, she said, and it's this big back and forth, and you get royal litigation, and like we said earlier, don't dabble in litigation. It's never fun. Fun for the attorneys, it's expensive, but not fun for anybody really. Yeah, let's go to the next one, unless anyone has questions about business entities. So, cool. So another big thing that we see, I feel like I need to trademark this line because I say it almost every single day, but good faith and handshakes goes about as far as the money doesn't. So get your agreements in writing. If you're doing business with someone, get a contract and get it in writing because, again, he said, she said versus the four corners of the document. You just want to, and contracts, they don't have to be looked at as this big adversarial document, right? This is simply an agreement that is going to define the relationship between all of the parties, and it's going to make sure that promises made or promises kept and that they can be enforced, right? So you're really, the law and doing legal stuff is all about risk mitigation and basically just trying to take as much risk out of the equation. So when you get your agreements in writing, you're just looking at the four corners, right? There's no more ambiguity about what you guys agreed upon because you don't have to get testimony from someone or bring in witnesses or any of this stuff. You just, here's the document, what does it say? That works, and you do it that way. So getting your agreements in writing, whether it's your services agreement, your vendor agreement, independent contractor agreement, employment agreement, whatever it is, just remove the ambiguity. Put that risk and do away with the risk as much as you can.
Yeah, and this is something I'll hammer home on as well, because it is just such a crucial point. A lot of the times when we're talking to clients, we use just a term that people are familiar with from the dating world, and it's define the relationship, DTR. We've all heard it, and it sounds silly when you think about it in a very professional aspect of like legal implications, but it very much is. Like you wanna outline, okay, here's what I expect from you, and on the alternative, here's what you expect from me. Just clarify everything. You know, if you're making water bottles and you're looking at your supplier who's going to make you the caps for your water bottles, you probably don't need some 30-page agreement that's super comprehensive and kind of over-lawyers the situation. You know, you can read the room and decide what's appropriate, but you at least want something, you know. I want you to deliver me this stuff by X date, and then maybe it's on a rolling basis, and then here's the price terms, and here's some other stuff, just in case the relationship breaks down.
Yeah.
But you need all this stuff in writing because it is really crucial to have it to fall back on in the event there is miscommunication. I mean, we all know just from reading text messages and emails how you can misinterpret tone quite easily. And that can be really bad whenever somebody misinterprets in a way that leads to a breach of the contract. So it's great to have these things outlined, spoken to as much as possible without overcomplicating the situation. And I will also add on to this. So everything we're pulling from this presentation is really in like a blog series that we have up on our website, which is HendleyGoodwyn.com. And so it's titled the same, it's Avoiding Key Legal Mistakes, but we're hitting information that's in each of these blogs. And one of the big things about getting your agreements in writing is your founders agreements. Like Andrew mentioned earlier, your operating agreement for your LLC. You want to speak to everything that the founders are getting into. You know, you are joining in this enterprise together, and so you want to make sure you speak to the relationship. And it's the same thing with passive investors. You know, what does a passive investor expect out of this company? What do the managers expect? And everybody who has, you know, degrees of relation to your company. So this is a little story about intellectual property. So intellectual property, just kind of broad overview. You got patents, which is protecting new novel ideas or inventions or business processes. That's something that our firm doesn't handle, but we know a lot of great patent lawyers, so if you need a recommendation for that, we certainly have it. And then you have trademarks, which is a source identifier of goods and services. And then you have copyright, which is how you protect your creative works. So a little story about Burger King. We all know Burger King. We all love Burger King. No one loves Burger King. I do. I like their fries. Okay, they get a bad rep. So Burger King, right? When they were franchising out for the first time, you know, putting stores in every state, they found themselves in Mattoon, Illinois. And in Mattoon, there was this business, this burger shop called Burger King. And so this owner of Burger King in Mattoon, Illinois, didn't have a trademark.
But he still had common law rights to the name Burger King. So common law rights, judge-made law, stuff that comes out of court cases and stuff. So when you register a trademark with the USPTO, you get what's called constructive rights throughout the United States and US territories. And so that gives you rights to that name in the entire US, even if you're not in that market yet, right? So if someone's coming into your market, you can elbow them out and say, hey, no, we have this trademark, it's registered with the USPTO, and you're afforded certain rights because you've been registered. If you're not registered, you still do have some rights, right? You're not just out of luck. I mean, you're out of luck in a lot of ways, but you have some rights, right? So the rights you have as an unregistered mark is you have rights to the name in the geographic area in which you used it, and depending on the use date when you started using it in commerce. So this Burger King in Mattoon, Illinois, I think it's still there if you go, and you won't find a Burger King, a franchise one, in a 50-mile radius of that city because the judge ruled, hey, this guy's been using Burger King for longer than you guys have been around, so he has rights to this name. Now, if he had registered his trademark with the USPTO, then he could have stopped Burger King from using that in the entire US, and Burger King would have had to do a rebrand, and instead we'd have Burger Queen or something like that, right? We wouldn't have Burger King as we know it. But since he didn't have those rights, all he's got is Mattoon, Illinois, which I'm sure is a great place. I've never been. So yeah, trademarks, source identifier of goods or services. And the process for trademarks is a long one. It used to take 9 months to a year. USPTO is a pretty efficient agency. However, kind of the tail end of 2019, there was this massive influx of Chinese applications at the USPTO, which has just bogged down the system a ton. So whereas before, when you would submit your application for a trademark, you would be assigned to an examiner within 3 months, sometimes sooner. Now, I'm seeing it take 5 to 6 months just to get assigned to an examiner, which means the whole process is being pushed back several months because their workload is a lot bigger. And they got a lot of great employees working at the USPTO, but I mean, volume, right? So the process now takes at least a year, I would say. I've seen it happen a little bit quicker recently, but it's pretty rare. Now it's taking a little over a year. But the positive thing about that is even if you register, you don't get that registration until a year later, you get that priority use backdated to the date of your application. So it's still something you want to do as soon as possible. And what I've seen happen when you don't get a trademark, no one expects to be infringing on someone or for someone to infringe on them, right? So it's kind of a belt and suspenders approach getting a trademark. You don't expect your pants to fall down, but if you do, you hope you have a belt. And if you don't have a belt, you hope you at least have some suspenders because nobody likes to be caught with their pants down. So getting your trademark is a little bit of belt and suspenders, right? You don't expect it to happen, but if it does, you're prepared for it. And what we've seen when people don't have a trademark and they come to us and they want to do a trademark, we do a search. We find that their name they want to use is taken or it's at least confusingly similar in the mind of the consumer. Then we're forced to tell them, like, hey, we think that this isn't a good candidate for registration and you need to rebrand. And that's a hard pill to swallow because when you rebrand, that means you're losing all of that, well, not all of it, but likely a lot of your customer awareness, the brand awareness you've made with the consumer, you're losing that because you have to rebrand. I've seen a lot of people creatively pivot, right, and say, oh, we're changing our name because it fits more in line with our mission statement, or they put out a funny video. I've seen a lot of creative ways to rebrand, and it's not something you want to do, so it's something you want to tackle as soon as possible. We know that small businesses and startup, a lot of it is driven by the budget, right? We just did our new professional photos yesterday. Before that, we took our own professional photos. They weren't quite professional. So we understand working on a budget. We understand the DIY startup life. But trademarks, they're important. They're more important than you think because you don't want to get a year or 2 years down the line, and once you start generating revenue, the company that has confusingly similar mark catches wind and they send you a cease and desist, and there you are in litigation again, which, again, don't go into litigation. No fun. So Mattoon, Illinois, great place to go for burgers if you don't want flame grilled, rolled Burger King stuff.
Yeah. The big key legal mistake to avoid here is neglecting your intellectual property. It is often I mean, now it's fast becoming the most important asset of any company. Think about, I mean, if you just look around the room and around, the rest of your day, you see trademarks, you see intellectual property everywhere. We've got it right there on water bottles that I'm seeing. We see it on, the EC's advertisements and graphics they have up. Exactly, it's entrenched everywhere. And the thing to think about is, what could be more valuable than a simple graphic or a phrase or anything like that causes somebody to buy your product? I mean, a lot of people do make really researched decisions when they're purchasing something, but for most people, that's major purchases. If we're talking like everyday goods and services,
it's pretty.
Yeah, it's very valuable. If you think about the supermarket, that's the classic example. How many things you see when you go through, or really anywhere, and if you see that graphic or that phrase that you've had a good experience with, then it causes you to reach for it again. And that's what's so valuable about trademarks. But when we're looking at your business from a startup perspective, you have an IP portfolio, you have trademarks, you have copyrights, you have images on your website, you have all sorts of things you use to market yourself and to get yourself to consumers and in their minds. And you want to make sure you have the rights to all of that. You want to make sure you clear anything you're using in advertising, whatever it may be. You want to make sure you just have the rights to it, or at the very least, a license to use it. So that's the key legal mistake to avoid. And if you're looking even more proactively than that, you can use IP to really leverage your position in the market. You can use it to not only protect yourself, but to grow your brand. If you're looking at selling your company eventually, which is what we all would like to do, is to walk away from things at a certain point, IP is going to be an asset that is on that due diligence list. If you don't have the rights to your IP, then your company is going to be worth a lot less. If you do, then you're looking at the opposite situation. Any potential acquiring company or individual is going to ask about your IP and going to want to be diligent about making sure you have the rights to that. So that's why we harp so much on IP. It's something it's very easy to address in the early stages of a company. Now, it can be addressed later, but like everything we're kind of talking about today, it becomes more cumbersome if you don't deal with it up front.
Yeah, it's, up front, right? Costs, it's not something that, having high costs is never fun, but I can promise you rebranding is going to be more expensive, fighting litigation is going to be more expensive. So build your budget and plan for those legal costs, because if you're running a business, you're going to have to deal with lawyers at some point. It's just a fact of running business in the US. So make a line item in your budget for legal services. Obviously, I'm biased. Also, fun fact, Music City Attorneys, you know who holds this trademark? It's Hendley Goodwyn. We do. Who would have thought that Music City Attorneys was still available? So, yeah, so we have this. Now, technically, there's likely someone out there who has some common law rights in there, but we won't talk about that for now. We'll deal with that when we have to. But we're in the USPTO. We're registered. What's this? It's pretty fun. So, putting our money where our mouth is trademarks important. Yeah, people call us up and say, "Is this Music City Attorneys?" And it always brings a little smile to my face. So they're like, "It certainly is." We got the trademark. So we definitely cut a lot out of this presentation because we won't have time for questions and stuff. But Holland's going to talk about some employment stuff because he's got an employment background, and a lot of that's just a little.
Yeah. So getting to the next piece of our blog, things you can again all find online because I know there's a lot of information to digest. But one of the key legal mistakes to avoid is falling afoul of employment and labor laws. The U.S. has a lot of comprehensive statutes or laws on employment and labor, and a lot of that is just born out of practices that have developed over time. So the big ones to keep in mind of are obviously wage and hour laws, and then Title VII, discrimination statutes. There are a lot of things about workplace safety and OSHA stuff. Generally that's not something to worry about unless you are, in a big manufacturing facility or you're a larger company. And I say generally because a lot of these employment statutes will not apply to your company until you hit a certain threshold of employees. Some of them kick in no matter how large your company is, or how many employees you have, how much money you're making. But other things, they kick in at a later time. So it's important to consider your situation with an attorney. Sit down and be like, hey, this is how many employees I have. This is where my company is at. What do I need to be apprised of as far as my employment contracts go, my internal policies go, all of this stuff. I used to work for a firm that was a plaintiff's labor and employment practice, so we went after companies all the time for wage and hour stuff, discrimination stuff, family and medical leave things, and it was great work, but it's really unfortunate because a lot of people do a lot of crummy things day to day, and you want to avoid those allegations. Not only because they can seriously damage your company, but it also tarnishes your just reputation you built up with consumers and potential talent. So it's a big thing to keep apprised of.
Independent contractor agreements, employee agreements. So this is a big one for startups, right? When you're scaling up as a startup, you don't want to have to hire a bunch of employees because you're opening yourself up to a lot of liability and a lot more responsibility. So a lot of people choose to go the independent contractor route. Now, you can't just say you're an independent contractor and all of a sudden they're an independent contractor, right? When the courts are looking, if they have to look at the difference, okay, are you a contractor or are you an employee? They're looking at a variety of factors and they're weighing those factors against each other. So to be an independent contractor, there's some of those factors include like, okay, how much oversight are you having on this contractor? How are they being paid? Are they being paid on a project basis, hourly basis? Are they using company equipment? Are they using their own equipment? I think there's like 8 to 12 factors depending on this, like 8 to 12 factors that they look at and weigh against each other to determine whether you're an independent contractor or an employee. And if they determine that they're an employee, you're going to be subject to a lot of these things, and you're likely going to find yourself in hot water because you've been treating your independent contractor as an employee. Now, one way startups kind of get around this a little bit is sweat equity. People working for equity in the company. And that's a great way to do it, right? So they can be a part of the company. You don't have to compensate them in a traditional way. You can say, hey, if you put in all this work, here you are on the cap table as owning 2-3% of the company, and which, at the start may not be valuable. But in the long run, sell your company to Facebook, that 2% all of a sudden becomes multi-million-dollar value, right? Now, that doesn't happen for every company, obviously. You don't have to be a big fish to make money when you're just sweat equity. But it's something that's very important to consider when you're getting started. And again, stuff that people don't think to consider because why would you think about that unless you went through law school and thought about that kind of stuff? But it's important, right? It's a very important part of your business and it's something to really think about. And again, an independent contractor agreement. It's real simple to write up, 5-6 pages, not super complicated, and it's just defining that relationship. And going back to contracts real quick and agreements, something I wanted to say is contracts can be oral. Contracts can be on a napkin. Contracts exist if you have a mutual meeting of the minds, so both parties have agreed on something. There's an offer, there's an express acceptance. The contract is legal, right? You can't contract to murder someone because that's illegal. And the person's of mental capacity, right? You can't make a contract with a minor. You can make one with a minor, but when they come of age, 18, unless you have a parent signed off on that, they can decide if they want that contract to exist or not. They can say, oh, you know what, I'm 18, this contract no good, I'm going to just cancel it. So a lot of things to consider when you're doing that, but ultimately remember that contracts can exist if they're just oral contracts, but when you have that ambiguity there, that he said, she said, it gets done. So anyways, back to employee stuff if we have more.
So to kind of like wheel about and take everything from like a holistic point of view, we've covered a lot of information, and there's more stuff that's not even in our slides here, but we have online on our blogs, things to consider. A big point to just keep in your mind is that every decision you are making has legal implications to it. It's unfortunate to think about it that way, but it just does. So things like, whether to make somebody an independent contractor or an employee, if you want to pay somebody equity, okay, you've got to make sure your employee equity plan is kosher. Does it comply with employment laws like ERISA and stuff like that? Does it comply with tax laws? Because sometimes you may bring on talent on the hopes that your equity package will lure them, and they might get a nasty tax bill at a later date, and then they don't want to work for you. But then, even beyond that, we've got securities laws that are at issue. And, securities laws came about in the 20s, or actually in the 30s, after, we had the stock market crash. A bunch of people went around promising people money and gold if you just invest in my company. What happened? People ran off with that money, those companies failed, and a lot of people lost a lot of money. So anytime you're offering, ownership in a company to somebody, you have to make sure that complies with securities laws, because that is a heavy statute to fall afoul of. And a lot of entrepreneurs, they need investors' money. You can't start a company without money. So it's understandable that you will have to take on investment, but the principle to keep in mind is that anytime you're selling, whether it's stock or LLC ownership interests or anything like that, you need to make sure you've cleared that with your legal team. You might have to file something with the Securities Enforcement Commission or anything like that. But I say all this because there's a lot of things to consider when you're doing business. Every decision you make carries with it legal weight, legal implications, and the whole point of this presentation is to help you avoid those key legal mistakes. We want your companies to grow and succeed, and you achieve your goals. A lot of you have awesome goals, whether it's getting a particular product out there or a particular service. You really want to make an impact, and you can definitely do it. You 100% can. There's just certain things you need to make sure you're proactive about along that way.
Yeah. That is, we covered a lot more of it in our blog. It's like a 7 or 8 part series that Holland wrote. And we talk about investor financing. We expand on pretty much all of these things. So if you want to check that out, it's on our website. Right now, we're happy to take any questions anyone has. If there's any questions that popped up in the chat, Parker, maybe not.
Yeah. As far as for startups go, what's the most common question startups have about, hey, am I doing this right?
Yeah, it's should I incorporate in Delaware? The answer is, for me, most often no. It's going to depend on who you go to, though, and that's we kind of touched on that a lot. But it's incorporate generally in the nerve center where you're doing business the most, because if you don't, right? If you incorporate in Delaware, that means here you have to have a foreign, I can't say foreign company.
Yeah.
Foreign company. You have to make an additional filing in the state that you're doing business in. So, yeah, incorporate where you're at. Delaware is, I'm sure, a great state, but far away. Let's hang out in Tennessee.
Yeah. The problem is if you're doing business here in Tennessee and you form in Delaware, okay, well now you've got to hire people to help you navigate Delaware's laws, and that's just going to add more transaction costs to the business you're trying to start. Money is, and the allocation of your money is crucial. So don't make decisions just based on traditional advice. It may be relevant to you, but it may not be. So it's important just to sit down and evaluate every decision based on your facts and circumstances.
Right. If you do incorporate in Delaware and then someone sues you, I mean, if you haven't been to Delaware, you're going to get to see what a beautiful state it is, because now you got to go out to Delaware and do some litigation. And we've talked about that. Yeah. So, yeah, that's definitely the most common one. Where do I incorporate? Yeah. Any other questions?
How long did it take you all to get Music City attorneys registered?
That one was actually the quickest one I've ever done, and it was like 5 months, and I'm not sure why that happened. I know I did actually speak with the examining attorney on the phone once. He called me, so sometimes it just happens that way, right? That's kind of another funny thing with the USPTO is that sometimes you'll get an examiner who's kind of a stickler and who is going to interpret things differently, right? And they're going to say, oh, this is going to be confusingly similar to this. When you're looking at it, you're like, in what world is this confusingly similar? And so sometimes examiners are going to harp on it, sometimes they're not. Most of the time, they're very consistent, I will say. But yeah, sometimes it just happens that way. So that was the quickest one I've ever done. Technically, we're only on the supplemental register instead of the principal register. The difference between those is only certain marks. Trademarks live on a scale of distinctiveness. So you have generic marks, which can never be trademarked, right? If you're selling donuts, you can't trademark donuts. So anything that's generic, right? You can't trademark apples if you're selling apples. But then on the other side of the spectrum, you have arbitrary or fanciful marks, right? So Apple selling computers doesn't make sense, right? But they have that mark because it's arbitrary for the good that they're offering. Fanciful marks, Kodak, for cameras. It's a made-up word. It's a Velcro, which is actually one that I think they lost their, that's another thing. This is a rare one, but there's times when your product or service can become so ingrained in the mind of the consumer. So like Velcro, if Velcro that was a trademark, right? The hook and loop. So they did their legal team put together this whole YouTube video. It's really kind of funny. And they have a song about Velcro. It's also very explicit, so don't watch it. It can sound like room with children. But yeah, their legal team put together this whole song, and I think there's a dance, trying to show the distinctiveness of their mark so they wouldn't lose that mark. So that's a very, very rare thing to happen, that your mark becomes so, like Kleenex and tissues, right? It becomes so ingrained in the mind of the consumer that you can't lose that distinctiveness. And then in between there, you have suggestive marks, right? Like Juicy Burgers, selling burgers, or like Luscious Lashes if you're an eyelash company. It suggests that you're doing, eyelashes, but it doesn't outright say it, right? Then you have descriptive right before suggestive, I guess. That's what we are. Music City attorneys, descriptive, right? Descriptive of the locality, Nashville, and descriptive of our services attorneys. That's what we are.
So Music City, that term is not traded.
No, so it has to be disclaimed. So the whole thing taken together, Music City attorneys, you can trademark that. Music City on its own is generic as to Nashville. Now, there is actually a mall in Louisville, Texas, where I'm from, called the Music City Mall. I don't know why they went with that name, but for them, it's not generic, right? Because no one surprisingly associates Louisville, Texas with Music City. So there are some nuances to it. But yeah, there's certain marks that are displayed, but the whole mark taken together is trademark. So,
yeah. And it's similar for other marks. You'll find like there's a case about a company called California Technology. Okay, well, you can't exclusively own the word California, so like we have to make you disclaim that. And you can think about how that would apply, depending on your other businesses.
What if it were like B&A attorney?
Yeah, I mean, that one's a bit tricky. I mean, it's owned by like the Metropolitan Authority, so.
Yeah, so you can't there's a lot of things in trademarks that are not trademarkable, right? You can't trademark like a coat of arms or government signs or symbols. You can't trademark something that's primarily a surname. And you can't trademark things that are derogatory. There's a lot of nuance to it. I mean, even that one, a recent Supreme Court case with, there's a band called the Slants, which they had their trademark denied, and they took it all the way to the Supreme Court. And they said because it's derogatory towards Asians. But the thing is, it was a band of all Asian Americans. And so they were called the Slants, and so they took that argument all the way to the Supreme Court, and they won. So they're allowed to use the slants, even though it's technically a derogatory term towards Asians. But they took it all the way, and they won. So sometimes you get around it.
Okay, 1 second. So you had that part about independent contractors. When would you suggest, because I think this is relevant to a lot of people, when would you suggest from a legal standpoint that your company is ready to hire a full-time person compared to just independent contracting, maybe 3 or 4 people? When are they ready to go set?
Yeah, it definitely, a lot of it can be dictated by the budget, right? Independent contractors are going to be cheaper. You can have them on a project basis, and you can cut them loose as soon as the project is done. So once you find that they're adding to the company in a way where you just can't live without them, really, it might be time to have an employee agreement written up. But again, a lot of that's going to be dictated by your budget and how quickly you're scaling and what sort of services and goods you're doing. So that can be a pretty fact-specific question. Because we have startups that have to start with employees right away, but they have massive investment, and they're able to do that. So yeah, dictated by the budget, which also, as a total aside, personal budgeting is definitely my passion. So if anyone wants to talk about that, I'd love to talk about budgeting, everything out here. So yeah, totally. Any other questions?
Yes. Can you hear me? Can you hear me? Hello? Can you hear me? I'm Candace Asher. Can you hear me? Hello? Hello? Damn. Can you hear me?
Yes. Oh, I can hear you. Can you see me? Hello. You sound wonderful. It's really incredible technology. There you go. Nice.
Sorry, Candice, I think you're muted.
I think it's just playing games with me. Can you hear me now? It's like I'm not doing it. Can you hear me now?
Yes, I can. I'm not sure about Andrew.
For some reason, I'm going in and out and I'm not touching anything. So, how am I doing? Andrew? Doesn't seem to be working. I'm sorry. Andrew? Andrew? Right.
Let's just end it.
Sorry, Candace.
No, that's all right. I'll talk to her. What her question was. But Andrew and Ron, thank you all so much. If y'all have any last words you want to wrap up with?
Yeah, I mean, these are our emails. This is our contact information. Just feel free if you have questions. We're happy to be a resource for you. We are advisors here as well. So if you
Excellent.
So if you see us, don't be a stranger. Feel free to say hi. And yeah, thanks for having me.
Yeah, thanks for coming. You're really great.